Well, good afternoon, everyone. How are you? My name is Joe Del Russo. Most of you know me. I am the de facto education coordinator for the Bar Association. And, we try to put together interesting programs. We had a forensic meteorologist here a couple of weeks back. Today, we're going to be addressing something more conventional. We have Yale Houtman with us. And for practitioners, this is important information. And even for general practitioners, this kind of stuff comes up all the time. And perhaps equally important, many of us are a little bit older. We may have aging parents. So even if we don't do this kind of stuff professionally, it's kind of nice to know if you have aging parents because it's not easy navigating these waters. There's no doubt about it. In any event, Yale Houtman is from Houtman and Houtman. And we realized we have something in common because I'm from Livingston. They're from Livingston. They know a lot of the same people that I do. And his firm is in Livingston on Eisenhower Parkway. It's been there since 1995, and he's still there now. And he practices exclusively elder, estate, and special needs law. And that's a very specific discipline, but it's something we're excited to learn a lot about this afternoon. He went to Albany Law School and is a graduate again of my alma mater, Rutgers University undergrad as well. He's got the usual professional memberships, Essex County Bar, New Jersey Bar, in the elder law section, of course. I'm interested in an article he wrote a little while ago. Perhaps I'll update it a little bit, but it's called "Be Nice to Me." I pick your nursing home and how to provide for your parents' care without going to the poorhouse or the nut house. My kind of scholarly article right there. But that's the kind of issues that the children who have aging parents face, and it's the kind of issues on a more sophisticated level, that we practitioners face. So let me introduce to you Yale Houtman from Houtman and Houtman, and I look forward to hearing what he has to share about elder law. And by the way, before he takes over, on October 14th, a member of his firm will be back, and we'll be talking about ethical issues in elder law and the related concepts. So Yale, it's all yours, buddy.
Thanks, Joe. I appreciate it.
Of course.
Good afternoon, everybody. So, um, my name is Yale Houtman. I practice with my wife and my son. We're a true family firm. And when we prepared and designed this talk a few years back, and we've given it to a number of attorneys, really was designed to assist, as attorneys, we field questions from our clients who respect us and think that we know everything about everything. And as the population is aging, I have found over the years that other attorneys have, field these questions that we're going to really address in this 75-minute seminar. Common misconceptions about estate and long-term care planning that attorneys need to know. And as Joe said, I think this will be relevant for you to answer some basic questions that you probably field not infrequently from your clients, but it also may be relevant to you. You may have family members, or you may start to think about planning for yourself. So without further ado, I'm going to jump in here. So I'm going to start with long-term care planning misconceptions. And when we talk about long-term care planning, it's not just for the elderly. Long-term care planning is a scenario where I might need assistance with what we call the activities of daily living, such as bathing, dressing, eating, transferring. And it can arise as I get older, but it also, we find it similar issues with folks who are disabled. They have chronic illness, disability, or cognitive impairments that cause them to need the same assistance with the activities of daily living. So it's not true that it's simply only necessary when I'm old, as I just explained. So a common question we get as attorneys is people want to protect their home. And so if I need long-term care and I want to qualify for government benefits, which we'll get into in a few minutes, what programs cover that care, But a very common question is, I want to protect my home. Will the facility, if I need nursing home care, will the facility seize my home or will the state take my home? It's not true. When we apply for Medicaid, and I'll get into it in a little bit, applicants may have to sell their vacation home and spend down the proceeds, but no one actually takes the vacation home. The primary residence, you might have to sell it or not, and that gets, I'll get into that in a little bit. But again, the state or any facility, long-term care facility, is not interested in owning your home. They're going to require you to pay for care. The state forces you to sell the home by denying benefits until you do, but nobody's actually going to seize your home. So let's talk about Medicaid eligibility financial criteria. And Medicaid is the primary government program that covers long-term care, but it is a needs-based benefit. So when we talk about home ownership, a primary home is an exempt asset and not countable for Medicaid eligibility purposes in the following scenarios. A single applicant, one that's not married, who lives in the home or has an intent to return to the home, as long as the equity in the home is not greater than $1.13 million. And these numbers, a lot of these numbers adjust from year to year. So in 2026, as long as your home is not worth greater than $1.13 million, really the equity, then the home is exempt. Secondly, if you're married and the spouse is living in the home, the non-Medicaid applicant spouse, then the home is exempt even if it's more than $1.13 million. And then thirdly, only the primary residence is exempt, not a vacation or a second home. That would be countable for Medicaid purposes, and I'll get into that in a few minutes. A very common question that we see that you may be asked is about something called estate recovery. And that's the idea that once you apply for Medicaid, Medicaid has the ability and actually the requirement to try to seek reimbursement of the benefits that they paid out from the person's estate. However, it works as follows. First of all, they can't seek recovery while the applicant or the Medicaid recipient is alive. Under federal New Jersey law, once the Medicaid recipient passes away, the state will seek to recover the funds from that person's estate for all Medicaid payments that were made after age 55. So this would be typically a scenario where somebody's on Medicaid on the long-term care Medicaid programs, not health insurance Medicaid, where somebody might be on that program younger than age 55. The estate recovery only applies to benefits paid out over age 55. And for Medicaid purposes, the home, bank accounts, annuity stocks, bonds, other tangible pieces of property are part of the estate. But there are also ways to avoid estate recovery. And the state cannot seek estate recovery while the person is alive. There's no lien on property. It only happens after the Medicaid recipient passes away. The lien, once it's placed, is based on the amount of Medicaid benefits actually paid. It's not based on any private pay rate that you may have paid. And in many cases, the Medicaid lien is never satisfied. It's beyond the scope of this talk, but I will tell you that there are many ways to avoid a Medicaid lien with proper planning, strategizing, etc. So common misconception. My family member can get Medicaid after paying the facility their private pay requirement. Well, the answer is maybe. And so let me back up a little bit. So if I'm in a facility, whether it's a nursing home facility or an assisted living facility, and I'm not on Medicaid, there's what's called a private pay rate, what the facility will charge me for care. But those facilities do not charge Medicaid the same rate. In the case of nursing homes, it's roughly 65% of the private pay rate. And in the case of assisted living facilities, it's usually around somewhere $3,500 to $4,000. So now, because facilities get more private pay than they get from Medicaid, some facilities are looking for a period of time. If I move into a facility or think about moving in, they want to get a certain amount of private pay from me. And so they might have a requirement. In the case of assisted living facilities, almost across the board, facilities require 2 years, occasionally 3 years at their private pay rate before they'll even make a Medicaid spot available for me. However, what this does not mean is that once I meet their requirement, I'm automatically approved for Medicaid, because I still have to apply and meet all of Medicaid's requirements in order to be approved. So both things have to happen. And by the way, I'm going to leave some time for questions and answers at the end, if anybody has any. So let's talk about Medicare. Common misconception: Medicare covers long-term care. Not true. Medicare is a health insurance program for people over age 65 or older, and for those individuals deemed disabled by Social Security. It is not needs-based. It's an entitlement program. You meet those requirements, Medicare doesn't care how much money you have. You're eligible because you're over 65 or you've been deemed disabled. The government program, this government program helps with the cost of health care, but it does not cover all medical expenses or the cost of long-term care, what we call custodial care. Common misunderstanding: Medicare will cover 100 days of rehab. The answer is maybe. So Medicare covers, there's hospitalization, Part A, there's doctors, Part B, prescription, not prescription, doctor's visits under Part B. Part D, for people that have it, is prescription drug costs. When you're in the hospital and the hospital is ready to discharge you and you're not ready to go home, but you need some rehab, that's under Part A. So you might go to a facility and need to rehab. Medicare will cover as much as 100 days, but it's not automatic. The first 20 days, they'll cover 100%. The next 80 days, they'll cover everything but a copay. This year, it's $217 a day. After 100 days, they won't cover it. However, you do not, for most folks on Medicare, they're elderly. If they are not making any improvement or deriving any benefit from the rehab, Medicare will not approve 100 days. What they typically do is approve in blocks of time. It might be 7 days, 14 days, and they're constantly reevaluating. And once they determine that the rehab is not having any positive effect, Medicare will stop, typically well short of 100 days. At that point, if you can't go home and you need to remain in a facility, now you're long-term, and then your options are pay the cost, which for round-the-clock care in our area can cost as much as $14,000 to $16,000 a month or more. Or if you have long-term care insurance, maybe that it might cover some or all of it. Otherwise, Medicaid is the only other option. Okay, let's see here. Rehab. So most seniors, as I said, do not get the full 100 days because they're too old, frail, or sick to be able to rehab. And Medicare only covers rehab as long as necessary to maintain the patient's current condition or to prevent or slow down further deterioration. So let's talk a little bit more about Medicaid. There's a lot of questions about that because that is the primary program that covers long-term care. However, Medicaid is not one single monolithic program. It's actually a series of different programs under what I call a Medicaid umbrella. And the programs that I'm going to talk about focus on long-term care. As I said earlier, there is a health insurance Medicaid program. Typically, that might be a single parent with young children on food stamps. Their health insurance is Medicaid. That's not what we're talking about here. We're talking about the programs that cover long-term care. And in New Jersey, we have a program that covers care in a nursing home, a program that covers care in assisted living facility, and actually two programs that cover long-term care at home. You must meet a certain income and asset limitation. That's why I say Medicaid is a needs-based program. And you must meet a medical test of needing nursing home level care, whether you're in a nursing home or assisted living or at home. It is a joint federal state program. So there are federal regulations, laws, guidelines that are supposed to be followed. The federal government allots money to the states. It says follow these rules, but the programs are administered on the state level. And so there are variations from state to state. So some of what I may say here, if you have family members or friends in other states who have heard differently, it very well may be because there are slight variations from one state to another. So let's talk about the financial eligibility criteria. So there's an asset test for a single applicant, one that's not married. That applicant has to essentially have no money to their name, less than $2,000. If we have a married applicant where both are applying for Medicaid, the asset limit is $3,000. And for a married applicant where only one of the spouses is applying for Medicaid, the healthy spouse can keep 1/2 of the countable assets, but only up to a maximum of $162,660. And the Medicaid or unhealthy spouse has to have assets less than $2,000. Common misunderstanding. Since my assets are held in a living trust, a revocable trust, they're protected and not considered an asset for Medicaid purposes. True? No, not true. There are trusts that are used as planning strategies to meet Medicaid's asset limit when an applicant has excess assets. A living trust is not one of them. These Medicaid asset protection trusts protect a Medicaid applicant's assets from being counted for eligibility purposes. They are no longer considered owned by the Medicaid applicant. There are many different types of trusts, but not all of them are Medicaid compliant. The trustee is the manager of the trust and controls the assets of the trust. Neither the trust makers, the grantors, nor their spouses can be the trustees. The trust must be irrevocable in order to be exempt from Medicaid's asset limit, but irrevocability by itself is not enough. Let me go to another couple of basic concepts. So there's something called the Medicaid penalty and a look back. So when I apply for Medicaid, I have to show, let's assume I'm single, I'll keep it simple. I have to show that I essentially have no money to my name, less than $2,000. So let's say I apply, and I'm looking for Medicaid benefits to start April of 2026. I have to show that my assets are less than $2,000 as of the close of business, March 31st of 2026. However, getting approved is not as simple as just showing a bank statement for March 31st. Medicaid also wants to know, well, what did I do with my money over the last 5 years? That's the Medicaid look back. So along with my application, I have to provide 5 years of records for every statements for every asset that I owned over the last 5 years to show what was going into my accounts and what was going out of my accounts. They're looking at money being deposited in because that may indicate that it came from another account that I forgot to tell them about and they actually had more money. And the money leaving my accounts, this is where the Medicaid penalty comes in. I have to prove that for any money that left my account, I received, and nobody else received, equal fair market value in product or service for the money that was drawn out of my account. If I'm married when I apply, then that money has to be spent for product or service that I or my spouse receive, but nobody else. If Medicaid finds that there were transfers for which I did not receive fair market value, or I just can't prove that I received fair market value, such as cash transactions that are not documented, those are what are considered transfers for less than fair value. Medicaid adds up all those transfers they find over that 5-year period, divides it by another number, which the state deems to be the average monthly cost of nursing home care. Right now, that number is $12,250 to come up with the Medicaid penalty. So for every $12,250 I transferred for which I did not receive equal value back, that equates to a 1-month penalty or waiting period for benefits, which starts after I've applied for Medicaid, met all the other requirements, and they've calculated this penalty. So let's talk about another common scenario. Someone may say, all right, well, I know that I can gift this year $19,000 per person. It won't impact my Medicaid eligibility, correct? No, not true. That $19,000 is a reference to the annual gift tax exemption, which says that I can gift $19,000 per person per year without having to pay gift tax. However, we're talking about Medicaid. And so while I won't have to pay a gift tax, that $19,000, if it's a gift, it's a transfer for less than fair value. And if it falls within 5 years of when I apply, then it will result in a Medicaid penalty of almost 1.5 months for every $19,000 I transfer. That's a very common one we see all the time. Let's talk about income. So there is an income cap or limit this year for Medicaid. This year it's $2,982 a month. If I have more than that in income, and the income we're talking about is only the income that comes to you as long as you live. So that is going to be Social Security and pension. It's not interest income because remember, I have to have essentially no assets to my name. So if I've spent down all the assets, I have no interest income. The only income I'm getting is Social Security and pension, which comes to me as long as I live. I can't reduce it. I can't stop it. And if it's over $2,982 a month, gross, before deductions, then I'm not eligible for Medicaid because I'm over the income cap, unless I use something called a qualified income trust, also known as a Miller Trust. And we get quite a number of calls in our office where people Google about Medicaid and they quickly come upon this QIT and they ask a lot of questions about that. But you don't set up one of these trusts years ahead of Medicaid. It's only necessary right before we're ready to apply. And it is not the type of trust that a few slides back, I was talking about Medicaid compliant trusts that would protect assets. This doesn't protect assets. All it does is it gets around the strict income cap rule. So it's a different type of a trust for a different purpose. And I should also note that when you're on Medicaid, Medicaid is a cost share. So there is a calculation. Most, and in some cases, all of the Medicaid applicant or now recipients' income will need to go towards their care, but that's it. The rest of it would be paid by the state up to the limit of what they'll pay. In the case of nursing homes, it's going to cover everything. In the case of assisted living facility, it will cover the room and board. But if the assisted living facility says, I need more care than they can provide, I either have to move to a nursing facility or I can hire private aides to provide the additional assistance, but Medicaid won't cover those aides if I'm in an assisted living facility. But that's where the planning and setting aside money in Medicaid qualifying trusts can be helpful, where we can tap into Medicaid, but then you have the assets to pull from the trust to be able to pay for the additional care. Common statement: I ran out of money, I spent everything down, I should be eligible for Medicaid. Well, not necessarily. There's the two-pronged test. I first must be financially eligible, and I've got to go through the entire Medicaid application process and provide 5 years of records and satisfy them. And then I also must be medically eligible. It is not enough to spend all my money legitimately. Medicaid will only cover my care if I meet the medical criteria. So an applicant must prove that he requires a nursing home level care, which is needing assistance with at least 3 of what are called the activities of daily living. Those are needing assistance with mobility, which is transferring from bed to chair, moving from room to room. Do I need assistance bathing, dressing, toileting, which is getting on and off the toilet and taking care of my needs? Do I need assistance feeding myself, not preparing the meals, but actually if a plate of food is left in front of me, do I need assistance eating it, or does somebody need to feed it to me? And then the 6th ADL is incontinence. Do I have control of my bladder, my bowel, or do I need to wear support pads? If I need assistance with at least 3 of them, and that is determined by Medicaid sending out a nurse to evaluate me, then I meet the test. The other way to meet the test is I may have cognitive deficits that, while hands-on assistance is not required, I need supervision and prompting with at least 3 ADLs. So while I might be able to dress myself, I do not have the cognitive ability to remember that I need to get dressed. I need prompting. I need somebody to be there to direct me and remind me, you got to put your pants on, you got to put your shirt on. So sometimes that's the way to meet the medical test. Another misconception. If I have a diagnosis of dementia, that means I meet the test of needing nursing home level care. That is not true. The test is not based on a diagnosis. Many folks are diagnosed with early stage dementia. But they do not yet need assistance with any of the ADLs. They're not ready. They will not meet the medical test. They're not ready for Medicaid in those scenarios. You still need the supervision. It's all based on functionality, not based on a diagnosis. And as I said, the state sends a nurse out to examine the applicant. The state and the state alone makes that determination. As I said, there are several long-term care Medicaid programs. So common misunderstanding, the New Jersey in-home Medicaid program will cover 24/7 care. That is not true. The most comprehensive program is the nursing home program. The least comprehensive is the in-home Medicaid program. I tell clients to expect on average 30 to 40 hours a week. Sometimes you will get more, but it's never 24/7. I've had clients that are quadriplegics being cared for at home by family, and at most they got 16 hours a day, 5 days a week. So it's never 24/7, which again is a reason why, if we have an opportunity to do planning well ahead of any application, more than 5 years, we can hopefully set aside money in a trust to then be able to apply for Medicaid, get the benefits that Medicaid will cover, and then supplement it by what's in the trust. If we do not do the planning, then before Medicaid will agree to pay, you have to spend all of your money down. And then when you find out that they won't cover 24/7 care at home, you have no money to pay for the additional care. You either have to have family members pay for the additional care if they have the financial means, or you have to move to a nursing home, which is where most people don't want to be. But New Jersey's system, the way the Medicaid system works, drives people to have to go into the nursing home if they haven't planned. My spouse needs Medicaid. If I move all of my spouse's assets into my name, I can protect the assets and qualify for Medicaid. True? Not true. The reason why people think that is they remember that, okay, if my spouse is applying for Medicaid, my spouse has to have essentially nothing to his or her name, less than $2,000. But what they're forgetting about is there's also an asset limit for the healthy spouse, because Medicaid treats a married couple as one unit. So we can't simply shift all the assets over to the healthy spouse, because there is something called the community spouse resource allowance. I spoke about briefly before. A community or healthy spouse can retain 50% of the couple's assets, countable assets, up to a maximum of $162,660. So if that spouse has that much times 2 or more, the maximum they'll get to keep is the 162. If the countable assets are 200,000, the healthy spouse only gets to keep half, 100. It's the lesser of of half or 162,660. The applicant needs long-term care and did not do any planning. It's too late to protect anything. Well, that's not true either. Even in what we call a crisis planning situation, we get plenty of those calls where family calls up, says, look, dad is in the hospital, needs to go to a nursing home. Can we protect any of the assets? And the answer is it certainly is possible through a couple of different strategies. If the couple is married, there may be an ability to buy an exempt asset in the name of the healthy spouse. So remember an earlier slide, I said a home is an exempt asset as long as at least one of the spouses is living in it. In the case of a married couple, there's no limit to the value of the home. So one way to protect assets is to buy a home or to buy a more expensive home in the name of the non-Medicaid spouse. There's also something called the disabled child exception. If a child has been deemed disabled by Social Security, there's an ability to transfer money to that child, and it's not subject to a Medicaid transfer penalty. Now, there are limits to this. We don't want to create a Medicaid problem for the disabled child if that child is on Medicaid or expected to be on Medicaid. So sometimes this exception is useful, sometimes it isn't. And then there's something called a Medicaid annuity. And what that is, it's a commercial annuity that if meets certain requirements, it allows us to take an asset and convert it into a stream of income. So if we have a married couple that has $500,000 of assets that has to be spent down, we can take that $500,000 and have the non-Medicaid spouse purchase an annuity, which converts the asset into income for that non-Medicaid spouse. Why does that work? Because while Medicaid looks at the assets of the non-Medicaid spouse for eligibility purposes, it does not consider the non-Medicaid spouse's income. That spouse can have as much income as they have. It will not prevent the Medicaid spouse from being approved for Medicaid. They only look at the Medicaid applicant's income, not the non-Medicaid applicant's income. So I know I'm going through a lot of material in a short period of time here, but the takeaway here is even in the case where somebody is in a nursing home, already spending money, did no planning at all, it is absolutely worth a phone call to explore crisis planning strategies to protect some assets. Now, pre-planning, to get through a 5-year look back when there's no care needed, that's always going to protect the most amount of money. But even when that's not done, crisis planning can still protect a large chunk of money. Because a house is an exempt asset, this is a common misconception. I can transfer it to my children, become financially eligible for Medicaid, right? Nope, not true. The house is an exempt asset held by the non-Medicaid spouse, but a transfer of that asset will subject both spouses to a penalty. So while the healthy spouse can hold on to the house, can sell the house after the other spouse is approved for Medicaid, that spouse cannot transfer those assets out of his or her name while the other spouse is on Medicaid. That would result in a Medicaid penalty, would result in a loss of Medicaid benefits. So it gets really tricky. I always say with regard to Medicaid and strategizing, timing is everything. Other considerations in terms of whether to transfer the house or not. So we get very often common questions. I want to transfer uh, I want to transfer my house to my kids. They'll call up the attorney. Can you do the deed? And sure, most attorneys can, the simple process of preparing the deed is easy and recording it. But is it the right thing to do? There are considerations. So, first of all, if I transfer my $800,000 house now and I might be healthy, I have no assurances that my health won't decline over the next 5 years. And I might need nursing home care, level care. And if I do, what's my plan? How am I going to pay for it? If I transferred my house and in 3 years I need care and I don't have enough money to cover it, I can't apply for Medicaid for another 2 years. Otherwise, Medicaid is going to assess a penalty for that $800,000 transfer. They're going to take that $800,000, they're going to divide it by 12,250, and that comes out to almost a 5.5 month, a 5.5 year Medicaid penalty. So I would never want to apply for Medicaid after transferring the house. I want to make sure that I don't apply until 5 years and a month after. But if I've transferred the house out of my name to my kids, can I get it back? Well, the children would have to give it back to me, but they may not. If I transfer to my son and he gets divorced, my daughter-in-law may raise a claim, a right to it. If my son declares bankruptcy, can't say, no, don't touch this. This is dad's house. It's not my house anymore if I've transferred it outright to my son. And then the other issue is losing a step up in basis. So if I transfer my $800,000 house to my son and let's say everything works out perfectly in terms of not needing to sell that house, and then I pass away and now my son sells it, well, I transferred it to him while I was alive. So he gets my basis. He doesn't get a step up in basis. So let's say I paid $50,000 for it and it's worth $800,000 when he goes to sell it. He has to deal with a capital gains of $750,000 and a tax on that, which is going to be six figures. And that's because while we transferred the house out of my name to him while we were alive, as it turns out, we lost a step up in basis. So we don't recommend transferring outright to children. There is a way to do this utilizing the Medicaid qualifying trusts to protect the house by getting it out of my name, but preserving the step up in basis and also ensuring that the house is somewhere that if I need to get it back because a month after I transfer the house, I have a stroke and I need round the clock care and I don't have the money to cover it, that house would have to come back. And then we'd have to employ some other strategies. But we have to be able to plan for that. So don't make the mistake of just preparing a deed for your clients who are not even considering this because they think it's an easy solution. Transfer the house now, get it out of my name, it's protected. We don't know if it's going to be protected because we don't know what's going to happen over the next 5 years. Okay, another misconception. I can hire a home health aide outside of an agency without any issue with Medicaid eligibility in the future. Not recommended. So this is a common scenario. So mom's living at home, kids get together, we want to keep mom at home. We call around home health agencies, it's expensive. I have a friend says, look, we hired somebody, paid her cash. It was a lot less expensive to do it that way. And so we're able to keep mom at home longer if we can pay a lower rate. Well, that is great for now, but if you need to apply for Medicaid down the road, if you're paying an aid cash or even a check to cash or a check to Jane Doe, there's no documentation to prove to Medicaid if and when you apply to show that there was value received from the aid. So while we recommend going through agencies, we recognize that a lot of families, it gets expensive. And even if you hire directly, we recommend a caregiver agreement and invoicing the aid so that you have the documentation down the road if you have to apply for Medicaid to show that those checks or cash withdrawals are not going to cause a Medicaid penalty or waiting period for benefits. All right, let's shift to estate planning misconceptions. So, see, I think I'm doing pretty good on time. Estate planning is only for the wealthy or the elderly. Not true. Anyone over the age of 18 should have an estate planning. Planning ensures that decision makers are in place with regard to your health care and your assets, and that your wishes with regard to the distribution of your assets are honored at the time of your death. So really, every person should have a will, a financial power of attorney, a healthcare directive. Estate planning documents, I can do them once. I don't really need to update them. Not true. And we're talking about a will, as I said, a durable power of attorney, a healthcare power of attorney, a living will, or trust. It is always important because life situations happen and every person's situation can change, and in fact, does change over time. That may be because of major life events such as marriage, divorce, birth of a child, death of a loved one, or significant financial changes. So you should always take a look at your documents, review them. We recommend that at least every 5 to 7 years, take them out, take a look and see if they still work. And if they don't, then there's a reason to update them. Common misconception. Well, I'm married. Do I really need a power of attorney? My spouse can do everything that and access everything I need. Not true. A spouse does not automatically have the authority to act on your behalf with regard to your assets or your health, even though in practice you might have had a health situation, went to the hospital, and the hospital took direction from your spouse. They're not really supposed to without the documentation. And as I always say, if they did so 99 times and then the 100th time somebody asks for a healthcare power of attorney and you don't have one, it's not really helpful that it worked the other 99 times. You still now have a problem. And so even spouses should have these documents in place. Not every financial asset is jointly owned. If husband and wife jointly own assets, then yes, they each have access to their accounts. But for example, retirement accounts are not joint assets. And so my spouse does not have the ability to access my IRA if necessary. Now, common response might be, well, my spouse is the beneficiary. Sure, but that spouse is only going to be able to access my IRA after I die, unless I have a power of attorney that gives my spouse the ability to access it while I'm alive. If something should happen that results in my inability to make decisions and I don't have a power of attorney, then in that scenario, a guardianship is going to be necessary. And we do a fair amount of guardianships in our office. And the most difficult ones to explain are the ones where a married couple, they didn't have powers of attorney in place. and the healthy spouse has to apply for guardianship and then has to answer to a court, and there are reporting requirements uh, that and assets have to be separated. And we have to explain to the spouse that, look, I know that everything was held jointly by the two of you, but now you're a guardian and you can't just, you have to separate out what's yours and what's your spouse's, and you have to report to the court and the surrogate what you're doing with your spouse's money, simply because no power of attorney was in place. On average, it takes about 2 to 3 months to obtain a guardianship. And if somebody's in a nursing home and we have to spend down assets and there's no power of attorney, then we can't do Medicaid planning and get to Medicaid without getting through the guardianship process first. Meanwhile, the meter's running on the care at $12,000, $13,000, $15,000 a month. So that can be quite expensive, to go through simply because of lack of planning. Okay. A married couple does not need, oh, sorry, I went back. I went forward and went back. Here we go. Powers of attorney obtained on the internet. They'll work for me, right? Not really. They're very basic. I also find that people that complete these documents, they sign in the wrong place. I can't tell you how many times somebody's presented me a power of attorney in which the principal signed for himself as the principal and then signed as the agent, got confused where to sign. And in essence, there is no power of attorney. Additionally, you want to be very specific. We have powers of attorney for our elderly and disabled clients that are tailored very specifically to cover the types of things the agent is going to need to do. So, for example, we find in dealing with financial institutions, insurance companies, they look at the powers of attorney very, very carefully. They scrutinize them, they send them to their legal department. If there is nothing in the power of attorney that specifically says the agent is authorized to do the particular thing the agent is trying to do, the financial institution or insurance company will say, it's not specific enough. We will not allow the agent to do that. So, for example, if we are in a Medicaid spend down situation, oftentimes the Medicaid applicants has life insurance with cash value, which is a countable asset. We need to switch ownership from the Medicaid spouse to the non-Medicaid spouse. If the power of attorney does not give the agent, who's usually the Medicaid spouse or sometimes the child, but whoever that person is, if the power of attorney does not give the agent the ability specifically to change the ownership of the policy, we have found that insurance companies push back and say, sorry, it doesn't specifically say you can do this. And so we're not going to honor it. And so a power of attorney that simply says, I designate my agent to do everything that I can do without detailing specifically the types of things is not going to be satisfactory. It's one of the reasons why our powers of attorney are 20 plus pages long. We have over the years revised and added to them to cover different scenarios that arise, so that if something is in the document that doesn't apply, it's as if it doesn't exist. But if we need it, it's there in the document. Okay, a diagnosis of dementia or Alzheimer's does not by itself mean the individual lacks capacity to execute documents. That is a true statement. As I said before, with respect to Medicaid, it applies similarly in the case of determining the capacity to sign documents. A person must understand what it is they're signing, who they're designating as their fiduciaries, and capacity can come and go. So as I always explain, if Mom comes into my office and signs her power of attorney, signs her will. I explain it to her. She understands it. She knows that she's meeting with me, that I'm her attorney. She's oriented to time and place. She signs the documents. Family goes out to lunch, and the children say, Mom, what'd you think about Yale and the documents you signed? And Mom looks at them and says, what are you talking about? I have no recollection of that. The documents are valid as long as when she was in my office and she understood what she was doing, even though later on, a half an hour, a day later, she doesn't remember signing them. She has to be present in the moment. And so sometimes when we have clients that have various stages of dementia, you have good days and have bad days. As the dementia progresses, the good days become less frequent, the bad days become more frequent. But sometimes we schedule a signing, and the family calls up and says, listen, Mom, Dad's not having a good day. Then we try to reschedule it for another day when they are in the moment. Obviously, if that's not going to be possible, then a guardianship is the only other option. A last will and testament always needs to be probated. That's not true. You only have to probate a will if there are probate assets that can only be accessed by probating the will. So sometimes a will may turn out not to be necessary, or it's not yet necessary. So there's no rush to probate. But sometimes issues come up 6 months later, sometimes years later, because nobody did anything with respect to assets and didn't realize it. But a probate asset is an asset that is in the decedent's name alone, that is not joint with right of survivorship with any other co-owner, and does not have a payable on death or transfer on death designation. So, what are examples of non-probate assets that do not pass by way of the will? Life insurance and retirement accounts and non-retirement accounts that have named beneficiaries payable on death. And then also joint accounts. So husband and wife had joint accounts with right of survivorship. One owner passes away. The other owner by law becomes sole 100% owner. Do not need to probate the will in those instances. Verbal instructions with regard to the distribution of your assets upon death is legally binding. Not true. Verbal agreements hold no legal weight. So we get this quite a bit when we're doing estate administration. And there's a will, it's probated. One of the family members said, well, Mom really intended something very different. She told me. And the answer is no, we have to be bound by the will. Mom had an opportunity to express those wishes by preparing and signing a new will. But if she didn't do it, then that verbal agreement has no legal weight. We have to be bound by the will. Without a proper legal binding document or a specific payable on death or transfer on death beneficiary designation, the state intestacy laws will determine how your assets are distributed. So if you have no will, then the intestacy laws will control. So all my assets pass under my last will and testament. Not true. Only probate assets pass. Examples of probate assets might be vehicles, real estate. That's not titled joint with right of survivorship. Bank and brokerage accounts that are not jointly held and do not have POD or TOD designations, and personal belongings that you might find in somebody's home, tangible items. If I die without a will, the intestacy statute will distribute my assets the way I would have wanted. Not necessarily. The intestacy laws, which cover what happens to somebody's assets when they didn't leave a will, or the will was not specific and doesn't answer those questions. There is a predetermined designation under the law, which New Jersey amended it a number of years ago. It made it a little bit more complicated, but if you die with children but no spouse, your children inherit everything. If you have a spouse but no descendants or parents, the spouse inherits everything. If you have a spouse and descendants from you and that spouse, and neither spouse has any descendants outside of that relationship, that marriage, the spouse again inherits everything. But here's where it gets more complicated. If the spouse, if you die with a spouse and descendants from you, and that spouse and the spouse also has descendants from another relationship, then the spouse will receive some of it and your descendants will receive some of it. And there's a whole formula here, which I'm not going to go, in the interest of time. I think I'm running out of time here, but it's a portion for each. And so this may not be in line with what the person wanted, but that's why we all have an opportunity to sign a will, to make those choices, because if we don't, then the state is making the choices for us under the intestacy laws. My children will owe estate and inheritance tax to the state of New Jersey when I die. Not true. So currently, there is no New Jersey estate tax. It was eliminated in 2018. However, we do still have an inheritance tax, but Class A beneficiaries are exempt from this tax. Who are Class A beneficiaries? A surviving spouse, parents, grandparents, children, stepchildren, or grandchildren. So that's going to be anybody in a lineal line, up or down, plus stepchildren. However, step-grandchildren are not Class A beneficiaries. And so then we look to the other classes. Class C, brother, sister, son-in-law, daughter-in-law, they will owe inheritance tax. Class D is basically everybody else, more distant relatives and non-relatives, they will owe tax. And then Class E beneficiaries are exempt from tax. Those would be charities and the government. So typically, where we have a client who has children and a spouse and they're leaving a combination of those people and grandchildren, they're not going to have inheritance tax. But if we have an uncle that didn't have any children, never married, leaves assets to nieces and nephews, that's where you're going to see inheritance tax. Or there might be a small gift to a non-Class A beneficiary, even though everything else is going to Class A, and then we would deal with an inheritance tax situation there. I can make financial and medical decisions for my children who are over age 18. Not true. So if you have clients, and nobody tells you this when your child turns age 18, all parental rights transfer to the child upon reaching the age of majority, which is age 18. When that individual turns 18, a determination is needed as to whether or not they can manage the responsibility of making important adult decisions. So if you find that you have a client that has a child with special needs and the parent believes that the child cannot make those decisions, then the parent really needs to consider a guardianship proceeding for that child. Because when that child turns age 18, the parent no longer has the ability to make those decisions. So I kind of, I think I did pretty well on time here. I leave a few minutes for any questions. How can we help you? The way our office is set up, we have an intake coordinator. Her name is Jill Diamond. If you have a need for somebody, a client or family member that you think we might be able to help, we're willing to talk to them and have initial consultation at no charge. Jill gathers the information we need to be able to speak intelligently about the person's situation so we can make that conversation as meaningful as possible. And, if you have any questions, you can certainly email us and with quick questions, we're always happy to provide that service as well. So I thank you all, and I think I've got a little bit of time here. Uh,
Yale, we have to give out
Yep.
the secret code now.
Right. Right. Thank you, Yale. Okay. The program code is CME15. That's CME15. And I will also put this program code in the chat.
Does anyone have any questions for Yale? I know I do, but I'll wait for the members. Yale, you mind if I give you a hypothetical from a real life scenario?
Go right ahead. Absolutely.
So the situation is as follows. You have an 84-year-old woman who most likely needs long-term care. She has more than 3 things that she needs care for. Somehow she got on Medicaid through her husband when her husband was alive. And I'm not sure how that happened, but let's take it as fact. She's on Medicaid. The husband died some years ago. She's on Medicaid as we speak. She has one asset and a little bit of money in the bank, not much, but one asset, and it's a $350,000 condominium, unencumbered. She's been in a hospital, rehab, and home, and she can't care for herself. She's become absented from the home and living with family. The family's taking care of her 24/7, and they're at wit's end, as you might expect. Is there any way to leverage or get something out of that asset? And she's been on Medicaid for at least a few years now. So is there any way she's sitting on $350,000. Is there any way to encumber that, get a reverse mortgage, some kind of wizardry to get some money out of that, maybe to go to a higher end long-term care? That's kind of the game here. Or a higher end respite care.
So, are you asking, is there any way to utilize the money utilize the house to pay for care? Or are you asking, is there any way to protect any of that money or
No,
both?
I think what's going on is the family recognizes that there's a variability in the quality of care. And some of these places are more expensive or,
Right.
does every place in New Jersey have to take Medicaid? Because I represented Arbor Terrace.
No, there are some facilities that don't take Medicaid, but overwhelming, there are plenty of facilities that do. And there's a misconception also that, facilities that take Medicaid are substandard. Um, by virtue of taking Medicaid, that's not true. From a marketing standpoint, if I'm considering facility A and facility B, and facility A takes Medicaid and facility B does not, and I have $150,000, let's say, to pay for care. But if that money runs out, I know I'm going to need Medicaid. And facility A takes Medicaid, I'm going to look to facility A because in my mind, I can't go to facility B because what happens if I outlive my money? I can't stay there. I don't have any more money. Even if the facility says, you're never going to run out of money. I'm saying, statistically, you're not likely to outlive that money. My answer or my family's answer is we can't take that chance. So that's why a lot of facilities will take Medicaid because I think they have to remain competitive. They don't want to lose that. And in fact, as it turns out, I may not ever get to Medicaid and they will have lost that money because simply I couldn't choose them because in my mind, I couldn't take that chance. So that I think that answers your first question. Now, in terms of what do they want to find a facility for mom? Is that what they're looking for?
I think that the belief is, and I think you kind of implicitly answered my question, the belief is that the the ability to utilize some of the equity in that house might allow them to have a greater standard of care, either by higher end in-person caregivers or a higher end place to go. And you're saying, you can go virtually anywhere with some limited facilities that don't take Medicaid.
Right. So if she's on Medicaid right now,
Yes.
okay, and she was, it sounds like she was getting at-home Medicaid, so they were paying for some care administered at home. When she applied, I'm surmising that if she had the house and she was applied when she was at that living at that house, the house was an exempt asset. Because remember, for a single applicant, the house is exempt up to $1.13 million. So if the house is worth I think you said 350, right?
Yes.
Okay, so clearly it would be exempt. Now, once she moves, if she moved to be cared for at one of her children's home, and she's no longer living in that house, and now that house is not occupied, um, that house is no longer an exempt asset. Medicaid just may not know about it yet until the next redetermination when they ask, okay, have there been any changes in the last year? And at that point, she would have an obligation to say, oh, by the way, I'm not living in my home anymore. I'm living with my daughter or my son. And so now Medicaid says, oh, well, you've got to sell the home. It's no longer an exempt asset because it's no longer your primary residence. And then she would have the money to, once she sells, to be able to pay for care. Now, an option may be for her to move into a facility, okay, now. What she would do is go to a facility, or the family would go to a facility, and she's already on Medicaid. And so she would go to a facility and say, listen, mom's on at-home Medicaid. Here's her Medicaid number. We want to transition her to nursing home Medicaid. And the facility, provided that they have a bed open and are willing to accept her, they would contact Medicaid and they would switch over. So now Medicaid would, instead of paying the aides, Medicaid would pay the facility. Now, once that happens, again, because the home is no longer an exempt asset, Medicaid is going to say, okay, you need to list the home and sell it. Okay. But in the meantime, Medicaid is covering the cost of her care while she's trying to sell the home. Once the home is sold and the cash comes in, goes into her bank account, boom, she's over $2,000. She's off of Medicaid. Now, I don't think this was the question, but I'll just carry this through. Once that happens, then she comes off of Medicaid, and let's say she gets $350,000. She uses that money and pays for her care at the private pay rate of the facility until the money is gone, and then she reapplies for Medicaid. That's one option. Another option is if she wants to try to leave something to her family, we could use a Medicaid compliant annuity, which is a little bit more complicated in a single person situation, but there's a strategy called reverse half a loaf strategy. And without getting into the weeds of it, there is a calculation we can make to determine, can we transfer some of that $350,000 out of her name, use the rest of it to purchase an annuity, a Medicaid annuity, so that that plus her income would cover the cost of the time frame of a penalty that will result when we immediately file for Medicaid after we do this. And then we have part of the 350 in the form of an annuity with her income would cover the private pay cost of the facility during the time frame of the penalty that results from the other portion of the 350 that we transferred out to the children. And so that's an example where some of that could be passed on as an inheritance, even after the sale, and even if she's in a nursing home at that point in time.
Sounds good. Thank you for that. And if I need to follow up, I'll give you a call. But I think I got the gist of it. I think it's a nice workaround if it fits the scenario of the family.
Yeah, it all depends on what the goals of the family are. Keeping in mind that we always have to make sure that we cover the cost of care either privately or through or a combination of Medicaid. Okay.
Any other questions before we break for the day?
Thank you.
Well, Yale, I want to thank you on behalf of the Passaic County Bar Association, Karen Corsi, and all the members. This was excellent. I mean, I'm interested in this, and like I said, my law school roommate's an estate guy, so I'm always picking his brain. But this was very boots on the ground. These are the common questions everybody has, so we really appreciate that, and I look forward to hearing your wife's presentation on October 14th. So, members, we're going to hear from the Houtmans again. Only we're going to hear from Yale's wife on October 14th, where she'll take us through ethical issues with elder care, state law, and related concepts that most of which we just looked at. But, how do we, stay out of the legal jackpot, so to speak? How do we conform our practice and avoid ethical issues? And we'll get ethics credits. How about that?
So, everybody's always looking for ethics credits.
Indeed. All right, Karen, I think that's it.
Great. Thank you, everyone. Thank you,
All right.
Yale. Thank you, Joe.
Thank you, guys.
Appreciate your time. Thank you
Have a
so
great day.
much. Have a great rest of the week, everybody.
You too.
You too.
Thank you, Karen. Thank you, Joe.
Take care,
Thank
guys.
you, everyone.
Bye.
Bye-bye.